Hello and welcome back to the channel. Thank you for joining me in another of my wonderful interviews. Today we're going to be looking at trusts and how you can protect your private property. We all know that we're somewhat under attack from all sorts of financial institutions. We've got the corporations, corporate Britain, seeming to give us an ever tight squeeze. And I know on this channel many of my viewers are fascinated on ways to try and find those ways to protect ourselves. And trusts have been something that I've been asked about many times. And so today we're going to talk to Peter Wilson, who is an ex-professional fighter. He's run his own martial arts gym for, I think, 40 years. I believe he went bankrupt and so decided to go and explore the whole world of contract law and has been doing lots of investigations on all of that and has set up his own private group to help others. And today he's here to help us, which is fantastic. Peter, welcome very much to the show.
Thank you very much. Thank you much. Thanks for having me. I'm very happy to be here to help others and spread the word.
Well, it's a joy to have you because, as I said in the intro there, people have asked me about trusts and I've tried to look at it. I did buy a massive, great big book and my eyes did blur over somewhat. And it does seem to be quite a maze of possibilities of all sorts of different trusts and all of that. So it would be good if you're able to sort of take us through some basics that people might find their way to protecting their private property.
Yeah, definitely. But just see, you've mentioned books. I'll show you a book that I actually read quite a bit and refer to. There are so many books, like you've said, and some of them are like bigger than a Bible that you could,
Yes,
the old-fashioned Bibles that you see. And then you try reading them and it's like, oh, But
that'll
this
be,
one, this is how do we get that in the camera? Trusts
there we go.
and equity, or equity and trust, I should say.
Yeah.
This one here is it's very easy to read. This
Who's
is
it?
from what we call a private law tutor. That's the publisher, private law tutor. And I actually got this like from Amazon. You can see it's not, massively thick. It's, and it's written in an easy to comprehend fashion. So, if you want to start on something like trusts to get a gist of it, then that's a good one that I would recommend for everybody.
Oh, brilliant. It's nice to know it's in easy language because that's something. I have got one of those great big Bible-y ones. And yeah.
Yeah, I mean, some of them are great. I mean, I've got them all up here, and you've got like I'm not talking about the law dictionaries. I'm talking about specifically for trusts. You've got
Mm,
Underhill's, which is like the law of trusts and trustees, and it's huge.
yes.
And I've got I like to get the original ones. But you've also got Gibson's. That's a very good one. Gibson's Suits in Chancery. So a lot of people would have heard of that Chancery Court, where they
Yes.
actually look at equity and trusts. But it's they are huge and sometimes a lot heavier reading than that one. So and
So,
this one really and another one as well called Gary Watt Trust and Equity. Again, it's written in an English language, really, where you can read it and think, oh, that's my words, I can read that.
yes.
And he actually goes back to give like a bit of a historic foundation, if you like, on trusts and equity and how it actually came to be in English law as it stands now. So that's a good read from him, and he writes it like quite easily to read along, as if you were reading like a book about, like, say, history of England. So it goes back to like Henry I, how he was actually trying to travel the country and settle the law to be common to all the land rather than having the lords of each like manor that were running it their own way, and nothing was sort of like level. It was all different wherever they went. But also at the same time, he was busy fighting in Wales, trying to like secure his kingdom in Wales as well. So he started to pass a lot, like the traveling court is what it was called. He started to pass a lot over to his chancellor, which was a bishop. It would have been a bishop, like like highly educated bishop, which
Yes.
is where this term now comes from, and that's really where it is now. The chancellor, he would have been what they called the keeper of the king's conscience.
Ah,
So
I have heard that term.
Yeah, so like equity really is using conscience, whereas like common law is basically very rigid. Did you do it? Didn't you do it? Are you
Yeah.
right? Are you wrong? Whereas on equity, what they'll do is they'll actually look at, well, what's the fairness of it, rather than
And we
just
certainly seem to be missing a lot of that at the moment in the our legislation.
very much so. But you know, a lot of it though is it's still all there, but they just try their best to hide it. So
Right.
when we're dealing with things that are not equitable, you're talking about a lot of people say, "Oh, I stand in common law," but in reality, when you say that to anyone in the field of what would you call it, law enforcement, they'll see that and comprehend that or understand, they probably would, that as judge-made law setting
Yep.
precedent in the higher courts. That's what you call common law.
Yes.
And when Henry the First was trying to make it common all across well, England at the time, and then trying to force it into Wales, it was so everybody followed the common thread of what was supposed to be his word being law. From being the king at that time, that's how it all came down. You had to do what the king said.
Yes.
But you know, so that's the thing. Now, when you're talking to law enforcement, let's say you know the police on the street, they wouldn't even know what equity meant. You know, they just simply wouldn't. So you know, there's times when to say things and times when to not say things because you're just going to be wasting your energy. But trusts and equity is still very much a very powerful tool to be used, especially when you're using it to protect assets. And really, that's what I've looked at more than anything else around down sort of like how to get equity for fairness in certain justice decisions, but rather on how to actually protect personal assets, be that your home or car or something of that's like.
And I think that's what a lot of people are feeling at the moment is how to protect ourselves. We've heard of things like the Great Taking. We've heard of, I mean, people have got themselves into a bit of a pickle trying to follow lawful practices, shall we say, and then the legal practices come on and say, well, we don't hold to any of that. We're coming for your goods or your possessions, and so that's where I think it would be fascinating to learn more.
Yeah, it's just on a point of that there. So, say for instance, you know, I've come across a lot of people, and generally you'll get the call like saying, "Well, I need help now. You know, I've got bailiffs at the door, and you know, I've tried to do all this, that, and the next thing, and now they're banging on the door and they want my goods." Well, if you haven't a lot of people, when they actually become aware of how corrupt this existence is, I think they do get a bit angry and kind of concerned, and they decide they want to go and fight the world at the same time. So, you know, they want to go and fight all of these corporations without thinking about it too much or even protecting themselves from the consequences, should we say.
Right.
So, you know, I sort of like liken it to like, all right, well, we're going to go into battle. So there we go. There's the army coming up. They're all wearing their armor. They've got their helmets down and everything. And we're just going to charge like, you know, the wild barbarians of the north. We'll just paint ourselves blue, run down naked, and probably get hacked to pieces. That's really what they're doing. They're just running into battle with no tools, no weapons, and no protection. So
Yes.
definitely not recommended.
No. So it's worth having your strategies in place well before you decide to engage.
Well, exactly. You know,
Yeah.
it's like, you know, loading, even to take it to modern warfare, you know, you're not going to run into battle and think, oh, I've left all my bullets back there. You know, you prepare yourself before you go into it. You
Yes.
know, hang on a second, it's the same type of thing.
Absolutely. So where should we start then in order to protect? How can we protect ourselves?
Well, let's just say, let's take it to the scenario that you just mentioned there, when you would have somebody saying, I'm going to go and take the goods. Now, I don't want to like split language and say, you know, oh yeah, but the goods means something this. Let's just say you were, you know, man or woman, and you're in this situation. Now, it comes down to your estate. That's exactly what they're talking about. So it can be from, let's just say HMRC, right? What they can only tax or attack, if you want, your estate. That's your full capital legal name. Now, we all know what that is. We know what it's
Yep.
doing, but it's called your estate. Your estate pays inheritance tax. You don't. Your estate gets taxed. You don't. Now, if somebody was going to come knocking on your door to take goods to sell to, repay a debt, for instance, they can only take it from your estate. So what that means is it has to belong to the estate, the full capital name. So if you remove all of your assets from your estate, in this instance, I do know some people who go and put it into their children's names and that type of thing. We're talking about their home, their property, right? But what you can do is you can remove it from your estate and place it on trust for a named beneficiary. And obviously you have to follow certain rules. Let's call them laws if you want, but it's like the laws coming under equity, which is the trust law. So you want it to be a lawful trust when you create it, and you need to act and speak in a certain way for that to actually be so. But as long as you actually look at the three certainties of a trust, as it states in the case laws, and how they want it to be created, then you'll be on quite stable ground if you follow those basic rules. But
Right.
really, what you want to do is remove the assets from your estate, your name, and have them somewhere else. Take them out of that cupboard and put them in another cupboard. Simple as that, really.
So, how do we do that?
Okay. Well, the three certainties that I mentioned there, you have the
Yes.
certainty of intention, the certainty of subject matter, and the certainty of objects. Now, from the studying that I've done, the courts will always, if it come to a court hearing and you have to prove that you've created a lawful trust, they'll look at the three certainties before they look at anything else.
Right.
So what you got to do is make sure you go over those three certainties to make sure you've covered all your tracks. You know what you've done. So the first one is, well, in no particular order, but let's say the certainty of intention.
Right.
So what they'll do is they'll look at the one that is creating the trust. It can be called the settlor, the grantor, the trustor, but it's the one that's actually making the trust, starting it, building it, creating it. A lot of the time in England, at least, they'll call it the settler.
Okay.
They will look at the actions and the words of the settler to make sure that their intention was to create a trust rather than any other type of contract or gift or anything along those lines. Was there really a trust created by their actions and their words? So let's just say, for instance, I have a pen, okay,
Yep.
and I'm going to say, Richard, I want you to hold this pen for me. It's very special to me. You have to keep a hold of it until I need it. I will recall it when I need it. You have to look after it for me until that time.
Okay.
Okay,
I've got it here. It's
there we
changed colour,
go.
but it's the same pen for the sake of the argument.
Exactly, exactly. Well, we have created a trust.
Okay.
So I have settled the trust. I've created it by my words. I've said, you are going to hold this asset for me.
Yeah.
You're going to hold it until I want it. So I'm
Right.
actually setting, even there, I'm setting laws. You've got to hold it until I request it. That is the law of that trust. So you are going to be what's called the trustee. You are going to look after it for me.
Yes.
Now, let's just say that I'm also the beneficiary. Okay, so or let's just say somebody else was a beneficiary. Either one, it doesn't matter. So I could have said, hold that pen until my friend Fred or my son Jimmy wants that pen, and you have to give it to him under this trust arrangement. Or I would just say under our arrangement. It is a
Yes.
trust.
Yes. Because you're trusting me with the pen.
Exactly. Exactly. So on the law of intention, did you speak in that fashion? So if I'd said to you, look, I'm going to give you the pen, you can do whatever you want with it, and you can give me it back if I need it sometime in the future. It's not very specific. I'm
Yeah.
not really saying you're going to hold this for me until it's time for me to give it back or give it to Fred or whoever would be the beneficiary of it, who's going to take a benefit from the pen. So, and if I said, well, look, here's this pen, it's yours, do whatever you like with it, I may ask for it in the future
Yeah.
if there's
And so
any
it's,
ink left.
that
Oh,
becomes, yes, exactly. It becomes very vague, and it could be misconstrued presumably as a gift.
exactly.
Right.
Exactly. So it has to be very specific. So this is where it comes into being an express trust. That's where it would be good because then you would write it down and it gets rid of any ambiguities. Like, what did you say? Well,
Yes.
I said this, and there it is written. So,
Yes.
that's what you would actually want. But that's the first certainty that they're going to actually look like, or look for, I should say. And there's plenty of case law that you can go over, and it will show you examples of what the judges like felt was the reality of somebody creating a trust.
Right.
Some of them's
Okay.
good as well. I mean, some of it where he's actually giving, they've had children, and he's put the trust goes, everything goes to the wife, thinking she's going to look after the children, and then she packs up and leaves. But there's nothing that they could do when the children, being adult children, we're saying, well, hang on, this is ours. You were said to look after her.
Yeah.
Where's the proof? The husband said everything was mine. He just thought I would look after you, but I don't like you.
Right.
Yeah, I don't like
Yeah.
my children. Hey, it happens,
Yes.
So that's it's got to be extremely concise on what you want. So you can say that a concise thing, and then you don't get what you thought you wanted because you haven't actually said you specifically have to hold that asset to benefit our offspring in the future.
Yes.
So again, be careful on what you actually say.
So that's the certainty of intention.
Yeah, so let's just say that's the first one you're going to look at. Did you actually speak and write down correctly to create that trust? The
Yes.
second one is going to be subject matter, which that's pretty self-explanatory. There has to be a matter, there has to be something. So we used the pen as an example. So that was our subject matter, the pen. So you're
Right.
going to be the trustee of that pen. However, it could also be a home. It could be a car. So we are going to say the subject matter, or what you're going to hold, my asset that I am giving you in trust, because I'm trusting you, and that's what the word means.
Yes.
Therefore, I'm going to give it to you, and you're going to look after it for me until, well, let's just say I was the beneficiary, until I recall it because for my needs, or until the other beneficiary, which is Fred, is going to actually need it, and then you're going to supply Fred with the benefits of the asset as he is the beneficiary.
So is there always a time limit to the trust? You're going to do this until such and such, or
Well,
not necessarily a time limit, but an end point of the trust.
Well, you'll have like what you'd call like an irrevocable trust. You have revocable and irrevocable. So if it's irrevocable, it means you can't change it. But what it
Right.
means in reality is like if I'm creating it, I give you that pen, and and I am only the settlor, right? I
Yeah.
can't then say, forget it, I want my pen back. I'm going to write a million letters. I can't do it because I've made an irrevocable trust. You hold that as trustee. You've got the power to then say, no, it's an irrevocable trust. You've told it to me. It's written down, hopefully. Therefore, I'm keeping the pen for Fred until Fred needs it as the benefits of it.
Right.
So and then you've got the laws on perpetuities. How long does the last? And it's changed a little bit. It used to be 80 years, and then they changed it, I think, recently to 125 years. And it's something about they've written it down something like the last surviving offspring of Queen Elizabeth, but now it'll be King
Right.
Charles, and
Yes.
that's how it's actually explained. But I mean, there is kind of a time limit, and what you will do is you can actually like create a new trust once. Because imagine when I'm dead, right?
Mm.
I don't really care in
No.
reality what's happened to the pen. Therefore, it can either dissolve or there can be a new trust created.
Right. Oh, okay. And so that was irrevocable, and and what was the other one? The
Revocable.
revocable,
Yeah, so it depends on
which
what you want it for. You can make it a revocable trust. You can say, well, I want you to hold this in trust for 10 years. And then
right.
if that 10 years lapses, then, and nothing's happened in that 10 years, then it comes back and it goes back to normal.
So
Or,
that's the one where you can say, okay, I'd like the pen back now. I'm instructing you to give me the return the pen, and you go, okay, fair enough, that's it.
yes,
And that's a revocable trust.
yeah.
Yeah. Brilliant.
So, we've covered the certainty of intention, you've covered the certainty of subject matter. So the next one is the object or the object, which is a
Yeah.
bit strange, really, but what it means is just the term, well, what's an object? An object is a brick,
Mm.
but what it means is it's a beneficiary.
Right. Okay. The object of the trust,
Yeah.
as in the beneficiary of the
The
trust.
object of
Okay.
the trust is to keep it for the benefits of a named beneficiary.
Yes. Brilliant. I have to say, Peter, you are putting this over extremely clearly, and I really appreciate that. Thank you.
Oh, that's good. That's good. I mean, the thing is, you've got to try and keep it as simple as possible.
Yes.
You can go down all of the completely, like lawful routes and go into every intricate, but that's really it. You've got your three certainties. That is always where if you got challenged, which, you shouldn't really, but if you did, that's where they're going to start. And you stand, and that's how you enforce your trust. Well, I've got the three certainties. So if
Yes.
you ever ask, because a lot of people will say, how does my trust work? Will it work if I get challenged? Well, firstly, I mean, like, who is going to be the trustee? So if the trustee, they'd have to know what they're doing. You can't say, oh, well, I'm going to use my son. How old's your son? 7. Well, you can't actually. You've got to be over 18. But you know what I mean? I'm
Yes.
simplifying it. Well, he's 18, the son. What does he do? Well, he doesn't do anything, right? He likes to go out and play pool while he's getting drunk, and he doesn't know anything about anything. He plays computer games, and you're not going to be a very good trustee. You need to have someone who you can trust with your life
Mm.
and who will stand in the correct way and knows how to talk on equity and the actual assets that are being protected by the trust. So any trust is only as good as the trustee you pick.
Right. And it can be a family member over 18 that is, you actually trust. Yeah.
Yeah, exactly.
Yeah.
So I mean, if anyone says, "Well, who should I pick as a trustee?" I mean, well, nobody can choose that except you, but it
Exactly.
has to be somebody you literally trust with your life.
Yes.
Now, what I mean, let's just look at some mathematics, all right? It would be great to say, well, I love my mother, she's fantastic, she's actually a barrister, right? So I'm going to choose her. Well, is she going to be here in 30 years' time?
Right.
When, say, for instance, if we look at normal, right, as in normal, as in like, generally, well, the parents will go then and it goes down that way. But so you wouldn't be using someone who's way older than you because generally they're not going to be there, when you're actually really needing it. So let's just say that you've put your assets into a trust. Let's just say it's your home, and you want it in the trust. You want the what we would call the beneficiaries of the trust to take, like, they're going to be there benefiting from that property, however that would be it like, a cash value of it, or is it like, a monthly income from it, or do they actually just have the asset and they move into it? I don't know. You would actually lay that out yourself in writing.
Right.
But that's generally how it would actually happen. So you would want somebody to be at least of an age where they're going to be there when leave this realm, as it was.
Yes.
So you
Yes.
can't just go, I'm going to use my great grandma, she's fantastic. She'll not let anybody through the front door. But, 3 weeks later, oh, I need a new trustee, you
Right.
know,
And
unfortunately.
can you, if you're the settler, can you be the beneficiary as well?
You can be, yeah. Yeah. I mean, there's certain ways that it can move around, but the way that I would recommend it is I mean, I've seen many trusts that have went to court, and where the set law and the actual trustees and the beneficiaries were all the same. And what they've done is they've laid the trust in front of the receivers because it was in a bankruptcy hearing, and they haven't been able to touch the assets because they're not in the estate of the one that's just went bankrupt.
Right. So
So, and
would
this
you
has been
name
proven.
would you name the trust?
You don't even need to use the word trust or trustee. It doesn't need to be
Right.
used.
Oh, okay.
You
So
know, that's
I'm
the
just
thing. It doesn't have to be written in such a way. I mean, I wouldn't. I'd be careful how I wrote it, but in reality, and again, case law and the lords and the judges that have actually stood in these cases have said, well, you don't have to say trustee, he's the trustee, and you
mm.
don't have to say this is a trust. In reality, you don't need to know. People do not need to know that there a trust exists for there to be a trust. But
Oh,
that might be a
right.
bit too complicated.
Yes.
Generally, we're looking at one where we want it to be expressed. We want it to be, well, this is my home. I want it in trust because of what's going on recently. And, like say, so certain people from the WAF say you're going to own nothing and be happy. I don't think many people want to be happy with owning nothing. So they're going to look at ways of protecting their assets. So that's the one we're talking about. But,
Yes.
in reality, you don't need to know a trust exists for there to be a trust in existence.
So let's supposing in that scenario you just said, and you think, okay, I don't want my house to disappear for whatever reason. I'm going to put it into a trust. I've got somebody, let's say my eldest son or my youngest son, whomever it is, that I trust to be the trustee to effectively manage it, and I also want to still be able to live here in the meantime, but I'll pass it on to my children when I go. So you've got your beneficiaries there. Do you have to then tell land registry and these people that the title or it is no longer in the estate?
No. And I'll just give you two scenarios, and these are actual solid scenarios that we're actually being in. So you can change it if you like, but
Right.
there's no need to do that. Now,
Okay.
when we've just been talking about those bankruptcy scenarios, these are voluntary bankruptcies, let's call them that. They
Mm.
found out they're in such a state that's thinking, do you know what? The easiest way out of this is just bankruptcy.
Yeah.
So, and if the only asset that you have is your home, but you've had it in trust for a long time, right? You're going to the bankruptcy court, and just so people would know, all you do is pay a fee. Can't remember what it's, £675. You're gonna no creditors that can then approach you or talk to you or bother you at all. They can only go to the receiver. The receiver, however, so you're going to go into the court. All they're going to do is they're going to look at the documents. Have you paid for it? Is it in there? The judge will stamp it, and it's just in an office.
Mm.
I've done it. So, and then when you do that, they'll send you to the receiver. Go next door. The receiver's there, and then you have to talk to them. And they'll say, "Where's the list of assets?" So let's just say that you've got your home, and this is what I'm telling you what we've done. So the receiver knows what is named in their mind in the assets. So
Mm.
first thing is they'll see you haven't put your home on the list. We've got it down as an asset. Why isn't it there? And they'll say, well, it's not in the estate. It's actually held in a trust. It's a private trust. Therefore, it's set up to be held on trust for a beneficiary by a trustee. The argument that we deal with every single time is that the receivers will go, well, we've checked with the land registry, and it doesn't say it's in a trust on a land registry. So our reply is straight away, well, the land registry, and we have the documents from the land registry, them arguing the point. They are not a governing body. They are not part of the government. They are independent, and they are purely a collector of information, and they sell that information to other agencies.
Right. Wow.
So they are
Okay.
not an authority. You don't have to worry about them. They are just simply collecting information. And we've set up, let's even call it a secret trust if you want. So, all trusts that are created by us are private, right? But just bear this in mind. If you go to see a solicitor and they say, well, we want to create a trust, they can, yeah, no problem. And then you say, all right, you've created our trust for us. Is this private? He'll say, yes, of course it's private. It's between me and you. And then what he'll do is register it straight away with the Trust Registration Service, which is another name for HMRC. So then they get all the information on the trust.
Right.
Does that sound very private to you?
Not as soon as you mentioned HMRC, it suddenly blew it out the window.
Exactly. So, so any trust would be classed as private between individuals like that, compared to a public trust like NHS trust and that type of thing, government
Right.
trust, that type of thing. So,
Yeah.
but just bear that in mind. Yes, you can get the solicitor or an asset management company to actually go and do that for you, but then they will go and register it with the Trust Registration Service, HMRC. So definitely private between you and them, but not private once HMRC are looking through your information and assets.
Yes. Right. So there you are. You've got your and presumably these people, if you're writing it down, their signature is to the trust to prove that they are there. Do you need witnesses and people like that to say, yeah, with everyone's agreed?
Yeah, I mean, what you should do, like I said, for there to be a lawful trust, you need the three certainties. But if you can prove the three certainties and you have verbally expressed a trust, literally, I have a private trust, or I have a trust, or I have my trust. That trust exists.
Right.
In English law, you just have to say it.
So
But
the problem comes when you've got to prove that, I
there you
suppose.
go. So you're talking about like if you needed to actually prove that in a law where they say, well, sorry, in a court where you would look at like, well, what about contracts? What about signatures? What about witnesses? So you would do it in what we call an express trust. So you're expressing it, you're writing it down. So you're going to say who's actually creating it. Although a lot of the trusts that we use don't even say who the creator is, the settlor, or whatever it is you want to call it. They've got the trustees and the beneficiaries. And what you would write the date on it, and then you would get witnesses to actually say, well, I've witnessed this created. So the trustees would sign it, and then the witnesses would sign it as well. And again, we've used them, photocopies of them, even putting them into the receivers in the court. And it's you can't really get any better fight than that. And
No.
there's nothing that they can do. Once it's seen it, it's got the date on, it's got the certainty of intention, certainty of subject matter, certainty of objects. There's the witness signatures to state that that was the date. What can they do? We know they can't do anything because we've done it many times.
So if you have a debt of some description that you are wanting to push back against or complain is unfair for whatever reason, whatever it is, and you've got the knock at the door from somebody collecting that money, and you're able to say, well, yeah, I know you want to collect the money, and I haven't got the money to pay you, and so you're now eyeing up, say, my car, and you're going to take that away and try and get the money from that and then give me the change. It's very kind of you, but I don't want you to do that. And I'm putting this very politely. Can you turn round to these people and say, well, actually, I know the car says that I'm the registered keeper, and maybe the DVLA are the owners because you've split the title and all that business. But can you say, I've actually got a trust, and it's in the trust, the
Well, most
estate?
definitely. So
Yeah.
again, as long as even if you are one of the trustees, which you can be as well. So if it's your asset, but you're going to be one of the trustees, so you're managing the actual trust as well. So you can be acting as the trustee, and as long as you've got documentation that you can provide and say, oh, that's in a trust, it does not form part of my estate, because that's where it all falls back to. Now,
Right.
like, let's just say that, I don't know, you've got a debt of some kind, then, we'd have to actually go through a court for them to end up knocking on your door anyway. They would have to have some kind of order. But so you should have challenged it, sorry, defended it well before that period. This is the thing that you'll find with a lot of people who are getting knocks on the door, right? They ignore all of the paperwork that come and say, well, we want to go and take you to court for this
Yes.
debt or for that, you know? So they need to be in the court actually defending it there and then, not wait until someone knocks on the door. Don't allow them to actually create a court order in the first place. Go in and actually defend it and say, well, that asset does not form part of the estate of, boom, the full capital name. So, and here is the paperwork to prove it. Because then what are you doing? You're talking to the judiciary, which will know the difference between, that at least they will have an inkling, which you could then be forcing through there, showing them, well, look, we have a trust. The assets have been placed on trust for a named beneficiary. There's the three certainties. We can show you case law, and you would have your evidence pile. But if you're talking to some goon that's banging on your front door with a brain cell he keeps in his boots, then this is where the problems arise because they haven't got a clue, and neither has anybody else. Like you've
Mm.
got like the police come at the door, they've got no idea what anything is. So you should be defending it well, well, well before that. But
Well,
the
yeah.
answer is yes. Once you've created the correct paperwork, and all trusts are just paperwork, you know, and
Yes.
it doesn't, it's not a regulated activity.
Right.
So, like for instance, you can't go into court and represent your friend or family because you need a license to be in court representing another person. Let's call them a person.
Yes.
Would it be in court? But on a trust basis, there's no regulation, so you don't have to be a qualified this or a qualified that, right? You can literally take out your own bit of paper and you can get your own pen, as long as you haven't given it to Richard in trust, and
Let
you
me give
can,
it to you back.
there you go, and you can write out your own trust. You can write it just in your handwriting, and there doesn't have to be, like I say, you don't even have to use the words trust or trustee. And then that will create, as long as you do it and you do it correctly with the three certainties, one, two, three, and you've got the beneficiaries that are going to be benefiting from it, and you've got the trustees that are looking after it, and it's all written out correctly like that, then there, that trust truly exists.
Well, that I mean, that sounds amazing. We often hear that there are these companies, as you I sort of said, like with a solicitor, but other companies who will do it for, all sorts of different prices, a few £1,000s or what have you. I'm presumably you'll get back a lovely, impressive package of papers and ribbons and maybe some wax seals, but all of that is a bit theatrical, is it? Basically, you've got a trust, but they're part of it.
Well, yeah, I mean, a lot of all companies are different, but you've got a lot of solicitors' officers will do it, and they'll have maybe what they might even have a trust writer that they work in the solicitor's office, and
Right.
they actually create all the trusts and they hold all of the trusts there. You also have asset management companies, which they're not legally trained; they just work on trusts. So, and they look after your assets, and there's various different levels of expertise, shall we say.
Yes.
You know, I mean, I have links with barristers. And so if somebody comes to me and they're a multimillionaire and they go, look, I want all of these assets looking after, I don't want HMRC taking everything. I'll pass them to a company that have barristers that have actually offshore trusts and look after everything and have a full team of people that do nothing but battle with HMRC. So there you go speak to them. All right.
Yes.
So, that's the benefit. I even have professional will writers. I say, look there, go and see them. They'll write a will. And we have other companies that will go and write a specific trust for the bankruptcy. And we have other ones that will write a trust to protect your assets. If you're just wanting to make sure your family are looked after, your offspring are looked after when you have gone. And that's generally what it is. Most people now should be looking at care home fees.
Right.
That's what
Yes.
you want to protect yourself from in the main realm. Because, well, fair enough. I live up in Northumberland. You'd have to have quite a huge house to worry about inheritance tax up here. I'm certainly not going to have to worry about that. In fact, I don't own anything anyway. But like the people that have got these houses, they're never going to be up to the levels that you would worry about. So really, what you're looking at is what could they do to me then? Now, I'm not talking about people that are trying to fight things and challenge things, and I'm being the man or whatever. But the councils love putting people in care homes because then they can take the care home. Sorry, then they can take your home to pay for the care home.
Yes.
Um, and it happens all the time,
So the
and
care home fees, the money that you would be spending on that care home yourself, how would you put that into a trust? Would that be what all your assets that might be sold to pay for the care homes,
that's
effectively?
exactly what the council do. They love it. So they
Yeah.
want your home, they want all your assets, and that you'll know what they do is that they'll section whoever it is to be put in the home. A lot of the times they'll put pressure onto like family, so well, you can't handle it, you're tired, they need special care, blah blah blah, and then they'll end up in a respite, they call it. And as soon as they got a hold of them, they're not letting go.
Yes. Yeah.
Um, and the fees, some of them are astronomical. You're talking like 3,000, 4,000 a week, so in some places. And what they say is, well, once you hit a certain asset level or your estate is worth, I can't remember what it is now, like over I think it's like 20. They change it all the time, but it was just over 20 grand anyway when last time I was looking at it. If you've got over that, then they want it. And that's
Mm.
it. So if you have a home, they're rubbing their hands together. They're going to take that asset and they're going to use it to pay for all your care fees.
Yes. So when you're writing your and you're getting your signatures of your trust, the other question that people have asked me is, do you need a notary to witness it all?
100% not.
Right. Brilliant. Okay.
Because what you're going to do now, we were talking about private before. So yeah, if it's between me and you, then it's private,
Yes.
right? But then if it's between me and the solicitor, it's still private in their mind, but then they'll go and
Tell.
report it completely. So
Yes.
when we are looking at the trust, we still come under trust law. So it comes, I mean, it's like they have to recognize your trust, but we're actually doing like a lawful trust, not a legal trust. So we're not going to write this act in or that act in. We're not going to write that in because then it makes it a public trust, or at
Right.
least it makes it subject to public acts. So we're
Yes.
not going to
So
go
this
into
is
our.
this is separate from acts and statutes and legislation. This is, and I think that's where people get very confused because they think, oh, hang on, it's a legal or a lawful trust. It must be part of the government system. But this is completely outside, as you said.
Yeah, it's a non-statutory trust. So
Brilliant.
when you're creating it as a statutory trust, which is what the solicitors would do, nothing wrong in
Yes.
that. You might need one. Everyone's got different circumstances. You might need something very specific and a necessity to have that. Good. Then they can register it and you'll pay whatever tax on it, and there you go. But if you're doing a lawful trust, so it's a non-statutory trust, let's call it that,
Mm.
then what you're doing is you're writing it without statutory legislation. You're not putting this is an act of this is an act of that. You don't use any public acts. What you're doing is you're standing as a man or a woman, and you're actually standing under the law, and you're writing it as like lawfully. So if you wrote it all like that, and then you go and get a public notary to sign it and stamp it, you've made it public again. You've actually dragged it back into the public acts. He
Right.
can only act under legislation.
Yes. Oh, interesting. Now, thank you for clearing that up because that's another. So well, how are you making that legit? You need a notary to do it, and as you've just cleared that up, so thank you for
See, the,
that.
the problem is that people don't believe in their own power.
Right.
So what they're saying is, oh, I need permission of somebody else to be able to live. I need permission of somebody else to write this trust. I need permission to own my own house. So, if I don't want to go to a solicitor, then they'll go on a public notary. They're not a solicitor, but they're still part of the legal system. And they can only like sign and stamp because they've got a license from the government.
Yes.
So you've dragged it back into the public acts again. We don't want to be part of the public acts. But I have, as a man, the right to live. I have the right to freedom, and I have the right to create my own trust. Now, as long as you think about it on a contract, in reality, once you've actually got a witness to a contract, then there is a contract. You can't say a contract doesn't exist. In reality, in a court, I know that is public, but if we actually create a verbal contract between each other and somebody is there as a witness and listens to that verbal contract, it's just as powerful as if it was written down.
Right.
So
Wow.
when we actually go and we create the private trust and we have two people, two man or woman who did witness, right?
Who
It's
did?
not a
Yes.
witness. They didn't witness it. They're a man or woman who did witness.
Who did witness it? I'm
So
I'm
this is
making notes as
present.
well.
We are in the
Yes.
present. They are in the present. It is not the past.
Right. Yes.
But then it's valid because you've got your three certainties of the trust. We mentioned them before. And then you've actually got it witnessed as well. So you certainly don't need anybody from the public acts to step in and validate. Oh, can we beg for permission, please, to do what we've done? No, you have a trust.
Yeah.
So
And I
again,
think that's a lot of people are beginning to sort of wake up to this whole idea because we've been given this notion that everything you have to do is you need to go to a solicitor, or you need to go to a notary, or you need to have the, as you say, permission from somebody. And it is quite a leap of faith for a lot of people who've been brainwashed in this way to realize, as you say, the power is with you, not always asking for somebody else in a governmental position to give you that power
well,
or permission.
yeah, that's exactly it. But it's the programming everyone's gone through,
Yes.
from the moment that we're actually come into this realm, and then going through school. You've got all of the indoctrination through school, 12 years or whatever it is in there, 100% indoctrination. Stand in a straight line, sit down, stand up, shut up. You're actually agreeing to being the person or the legal fiction every registration when they say your name. That's black magic. They're reading out your full capital name and you're saying, yes, miss, yes, sir. So you're agreeing to being the person. You're being, showing your behavior You're going to be a perfect little factory worker. Get into the factory, keep your mouth shut, do what we say, die, and then we take everything from you.
Yes. And they do a good job of that. So if it's your car, is the DVLA like the land registry, just really an information bureau that is just keeping the knowledge, the titles, and blah blah blah, and you put your car into a trust?
You can definitely put your car into a trust again through the bankruptcy side. We've done it, right? The car was actually put in a trust. The argument was from the receivers, we've never seen that. That what? No one's done that before. 30 years I've been doing this job, no one's done it. And the guy holding it said, I did. And they were like, so if there's a trust created and it's written down correctly, then there you go. There's a trust created. So I mean, that wasn't, an old banger. That was like, an expensive
I'm
car that was
sure.
wanted to be
Yes.
protected, but same thing still worked. Um, Now, what we're actually saying is like, as long as you remove the asset from your estate.
Yes.
So,
Would you?
like the
Would?
house, you don't have to tell land registry because they are simply a collector of information. I mean, we actually heard a video the other day saying that DVLA keep the manufacturer certificate of origin. So I've asked them for it. They haven't even replied. Two
No.
weeks later, still never replied. Other people have done it and sent it off and said, well, we haven't got a clue what you're talking about. They're never going to admit anything, are they? So, but
No.
you can change it if you wanted to say, of the private trust on there. But you can still just have it as long as you have the paperwork saying, well, look, I've got a statement of interest here that says this car is on this trust, has been since this date. There's the trustee, there's the actual item, which says the car. It's not in my estate, it's not my asset. So if you want to take something, then take it, but you can't have something that's not mine. I mean, in reality, that's just like me going round to your house to say, look, go and get Richard stuff because I know him well. Yeah, I like him. He'll bide me. He'll vouch for me and let you take his stuff. Has to be in your estate. That's the whole thing. Take it out
Mm.
that cupboard and put it in another one.
Even though you've still got the name of the registered keeper, and it's not affecting your insurance or all those sort of things.
Yeah, exactly
Yeah.
that. So I mean, even if you changed it, right,
On the V5.
to on the V5 and you changed it, I don't know, to say trustee,
Mm.
then but you are also the trustee, then are you still not the keeper?
Well, you may well be the keeper. Somebody's got to keep it, haven't they? According to
Yeah,
them.
exactly. So what they're saying is when you fill in the insurance thing, they say, are you the what do they say? I can't remember. It's been a while. Are you the
Mm.
keeper? Like, is the keeper the driver? So if you're the trustee, then you're keeping it, then yes. And if you're driving it, then it's still yes. So yeah, you just agree with what they say. Do you legally own it? Well, a trustee always legally owns, possessory owns the actual asset. So if you assign your property on trust, you literally give it away. And if it's irrevocable, you can't ever ask for it back, which
Right.
means that that asset, be it your home or your car, no longer belongs to you at all. Legally, it belongs to the trustee. Nobody will argue that.
And nobody can make you change it from revocable to irrevocable.
Well, you can change
Once
if,
it's
if it's revocable,
yeah.
then
No,
you
the
can
powers
revoke
that
it.
be. Yes, the
If it
powers
was the
that be.
opposite way around, then no,
No.
because
Yes.
you've decided.
But the powers that, let's say, for whatever reason, the government said, or HMRC said, well, you've got to sell your car to pay this bill, and you say it's in a trust, and it's let's say it's a revocable trust, so that you could take it back if you wanted. Could then the government say, well, we'll force you to take it back? Can they force you to take it back?
So let's go back to the three certainties. If you've done the three certainties that can prove there's a lawful trust, you might have a statutory trust created by a solicitor that only lasts 10 years.
Right.
And then for whatever reason, then as soon as that 10 years has passed, that car, example, will now become the full owner benefits of your son, right? Or whatever you wanted to actually write
Yes.
into it. So it's still held on trust though until that 10 years is up. So if it's not legally yours, no one can take it. So
Right.
what you're
And they
doing is
can't.
you are legally giving up ownership.
Yes. Brilliant.
So remember, so if you were my trustee and I've given you my car, right? You're only the holder of it on legally. So you legally own it, but you'll actually legally own it in what we would call segregation. So if you went bankrupt, they couldn't take the car because you're the trustee of it because it's held in segregation.
Yes.
So yeah, your bankruptcy wouldn't matter to that the effect. But you are the legal owner of the actual asset. So I'm no longer the owner. I've literally given up ownership. So they can't take something from me I don't own.
Yes.
That's what it boils down to. If you've got it on trust, right, and they say, well, a debt collector comes, say, well, we're going to take everything you own. No problem. Here's what I own. What? Nothing.
Yeah.
Like all you got to do is look
I've
at
only owned this pen now.
well, here we go.
That's all I've got left.
So if you look at all of the wealthy, the really wealthy, and even the royals, they own nothing.
Yes. They just got access to using it all because they're trustees of it and
They're
beneficiaries.
beneficiaries.
Right. Yeah. So let me ask you this then. We hear of public trustees, as in judges, people in the council, government ministers, and that. Are they public trustees? Is there sort of a bigger version of the trust that we are the beneficiary of things, and they are there to act as trustees for our towns and villages and that
Well,
sort of thing?
some would say so, and obviously they're saying that everything's got put on trust. I mean, if you have a look, really, the biggest proof of that, let's have a look at the land registry. So anybody that owns the house can go and check now, get your deeds, get them out, have a look at it, and it'll tell you point blank in black and white, you are the tenant. If you've paid your mortgage off, or even if you were lucky enough to actually have enough cash to buy that house, right? You've paid it off, you do not owe a penny, right? You are a tenant. That's all you are. A tenant on the land. You do not own it.
Gosh.
So, because why? Because that say, well, it's all owned by the crown, therefore it's all held in trust for them. But you can only be a tenant on the land with a fee simple. So
Yes.
you have to go and check your uh,
Deeds.
title deeds and see that, and then you'll see that that's there. So yeah, I mean that could be the case, right? It's I know that everybody wants to chase off and try and find their trust fund and
Yeah.
this mysterious fund, etc. But you know, it's a different kind of story altogether, that one. But yeah, that for the land registry for sure. I'll just go and have a look. You are a tenant on the land.
Right. Oh, okay. I just thought I'd ask that because that is something that other people have mentioned that you can say. Well, I mean, public servants, for example, are supposed to be our employees because we're all collectively paying to them. And I wondered then if is it illogical to say that they're also public trustees, that we as beneficiaries can say, well, you're not doing your job very well, we can call you to account because the trustee is effectively not doing his duty.
It should be like that anyway, shouldn't it?
Right.
They're all supposed to be in a public office and they should have sworn an oath in the public office, but none of them seem to give a toss about that right
No,
now, do they?
exactly. No. So it's very difficult to hold them to account whatever happens because they
Hmm.
just sort of ignore and don't reply. Like you said, they just don't reply, even though you're asking them very simple questions. And they, like with the certificate of manufacture, and they just don't want to. They don't want to give away their secrets.
No, exactly that, and we specifically asked for it because I was told. So rather than believe anyone else, I want to go and investigate it. So we've wrote off
Yes.
and we've done everything we're supposed to do, send it off. Lots of people that I do know did it with me, and they've all got a reply just saying, no, we don't know anything you're talking about. It doesn't exist. It's all done away from us. We don't know anything. I haven't even got a reply yet. No, not
No.
talking to me. So anyway,
Fair enough. Well, thank you so much for going through. I mean, it seems on the face of it a very simple process, but knowing and understanding what you've just told us, can you just hold up that book that you were referring to one more time in
yeah,
case
for
people want
sure.
to have a look at it? And there we are: Equity and Trust, Last Will, and what does that say? Testament.
That's
Testament.
Will and Testament, and it's
And
by the private law tutor. I don't know if you can see that on there.
oh yeah,
Bit
private law
blurry.
tutor.
Private law tutor. So I think if you even just put that into Amazon, you'll come up, and it's got It's got some very, very good explanations that you will be able to read,
Mm.
compared to some of those great big Bible books that
Yes,
you can get as
yes.
well. But I mean,
So
it
it's
does take a lot of studying if you want to get to grips with it. And remember this, so that everybody can create a trust. I mean, you could literally write it on the back of an envelope. It does not matter. I don't recommend that,
no.
but like in essence, that's exactly what it is. But when they say, well, how powerful is your trust, right? Or how powerful is like this company's trust? No, how powerful is the trustee you're picking?
Ah, yes.
I mean, as long as you have it written down with the three certainties, certainty of intention, did you intend to create a trust? Have you written it down? I am giving this asset of the car to Fred. He's now going to be the trustee of it for Jimmy, who's the beneficiary. If you've written it down like that, that's quite clear. So there's your certainty of intention. Then you've got your certainty of object matter. Well, it's the car. There's the car. The car is what's going to be held on trust. So that covers that one. If you've got the certainty of the object, who is the object? Who is the beneficiary? Jimmy. Fred is holding it for Jimmy. It's quite clear. It's it's
Yeah.
it's not ambiguous whatsoever. So that is the certainty all covered, the three certainties. So really, if you've got that written out like that, and then you explain it to the trustee who can say, well, I'm going to stand under equity. So a trust relates to equity, so it has to be fairness, but it's also in a completely separate jurisdiction. It's not under statutory legislation, it's created under equity. Now, it actually states that you can even go back and have a look at the actual law, and it tells you can do that. But you're doing it on a non-statutory basis. So you're not relying on the any acts or governments or parliaments or anything to do that. This is a trust, and there it is. It's written out for you.
Fantastic.
And again, we've been into the court situation and argued it plenty. And as long as you've got it written out and it's done like that and very, very clear, it's written out there, and the trustee can stand on it. So you can have it all written out and never speak to your trustee. They went, yeah, no problem, I'll do that for you. You don't explain anything, and then you're not there to talk anymore. The trustee goes in and goes, well, I don't know. Do you want to read it and
Yes.
tell me what happens? If you pick that trustee, you trust them with your life, and you make sure they know what they're talking about when it comes down to it.
Peter, really appreciate that. Can people get in touch with you? Do you have a website or a group that you'd like to promote or
Yeah,
have?
yeah. The best thing to do is just you can either look at the website, which is like claimyourstrawman.com, or if you want to email, then gold@claimyourstrawman.com.
Claimyourstrawman.com. I'll put that in there. And presumably all the links will be on from there, and people can.
Yeah,
As you
you can
say,
go
yeah.
into there, they can see it. I mean, we've got like that'll just show you the private group. They've even got a big video section. They've got like a notice section, lots of free stuff that they can go and look at in there as well. So very, very helpful. Yeah, but so certainly do that. Oh, go and look at my channel as well. Return to True Democracy.
Return. Is that a YouTube channel?
YouTube channel, yeah. Return to True Democracy.
I will add that to the links, and hopefully send some viewers over there who are fascinated and interested in this subject, which I'm sure. And thank you again for being so very clear, because sometimes you get people on and they're trying to express it. You've expressed it incredibly clearly, which is so great.
Oh, good.
So I really appreciate that, and thank you for your time and wisdom.
Yeah, you're more than welcome. More than welcome. Thank you very much for having me on again.
It's my pleasure. So there we are, ladies and gentlemen. Claimyourstrawman.com, Return to True Democracy on YouTube. All you ever needed to know to get you going on trusts and protecting your property. I should certainly be looking at it myself. Thank you so much, Peter. It's been a joy to talk to you. I hope one day I can get up to the lovely, beautiful countryside of Northumberland, because it's very beautiful up where
Especially
you
on
are.
days like today, it's gorgeous.
Yeah, absolutely. And it's such a rare thing at the moment.
I know.
But there you are. Until next time, ladies and gentlemen, thank you so much for watching. I'll be back with more monologues and more wonderful guests. But from Peter and myself, take care, look after yourselves.
Thank you.
Bye for now.